Hi, everybody. I'm Emily Smith. I'm the Executive Director of Wyoming Guardianship Corporation in Cheyenne, Wyoming. And I'm here with the Director of Life Management Services. She can introduce herself.
I'm Jessie Westling. Hello, everyone.
And we're here today to hopefully give you some education and information on how to be a good guardian. This presentation was formulated for people who maybe are volunteer guardians, who are family guardians, not necessarily for professional guardians, in the hopes that, Wyoming is a really rural place, a frontier area, and we're hoping that we have a lot of people who need guardians and not so many people who provide guardianship. So we're hoping that this presentation can help people feel more comfortable with being a guardian, a volunteer or family guardian, and understand better how to provide that service to people in their community. So we have a PowerPoint presentation that will go along with this, and we'll go ahead and get started for you. All right, so here we are. Here this is Guardianship 101, how to be a good guardian. And I think there's a couple disclaimers at the beginning here. First of all, guardianship is different in every state. Everybody has a different statute. Even if you have the Uniform Guardianship Act, which some folks do, Wyoming does not have that yet. So please take into consideration if you're in another state. But we're talking about Wyoming, and while in general, there are some things that are same, especially when we talk about the National Guardianship Association, which has so conveniently offered us standards of practice and ethical guidelines that you can apply anywhere. We heavily rely on that in this presentation, but every state does have a different statute. So the other thing is, nothing in this presentation should be considered legal advice. We're not attorneys and we are not giving you legal advice. And then finally, this presentation is about the guardianship of adults. So, all right, well, let's start out with what is guardianship? So guardianship is a procedure where the court determines that someone is not capable of making their own decisions because of some type of severe disability, and that person needs some kind of a protection. It's a legal proceeding. And it's a tool that allows one person, or in some cases, multiple people, if you have a co-guardianship, or an organization, in our case, Wyoming Guardianship Corporation, to make decisions for another person. And so there are two types of guardianship we're going to be talking about today, and that's guardian of the person and conservator. So what are the responsibilities, sort of in general, of guardian of the person? And Jessie, you just jump in here if you feel like you need to add anything. But guardians ensure the care of the person they are guardian for, and we'll go into more of these sort of at length. But they determine the most appropriate and least restrictive place for that person to live. They make medical decisions. They provide general oversight of the person's finances. And they also ensure access to appropriate educational, social, other activities and social services for the person that they're guardian for.
And I think, too, to mention, depending on the court order for the guardianship of the person, that there might be other responsibilities that are particular to that situation.
Or less responsibilities.
Yes. So that can all be spelled out in the court order.
Absolutely. You can say, the court order could say, accept medical decisions, and then you wouldn't be able to make those. So, yeah, it could be any or all or some.
So you really need to make sure that we're looking over court orders.
And don't worry, I think we have a whole slide on that.
I think we do, too.
So what is a conservator? Well, a conservator, and again, this is Wyoming language. Some other states have some other language, but a conservator is appointed to manage a person's estate or finances. Someone needs a conservator when they have more income than just, for instance, Social Security income. If the person owns real property like land or a house, if they have investments, or if they have any type of an estate. Conservators manage all the financial affairs of a person who's under a guardianship. So you might be asking yourself, who needs a guardian? A person might need a guardian, and again, this is Wyoming specific statutory language, but if they're unable, unassisted to properly manage and take care of themselves or their property as a result of a disability. And then in Wyoming, they go on to say what those might be: advanced age, a disease, alcohol or controlled substance dependence, a mental health illness, or an intellectual disability. And then, of course, a guardian is someone or an entity who makes decisions for another person. So guardian of the person or conservator, or you can be both. So another thing that we get a lot of questions about here in Wyoming at Wyoming Guardianship is, how does the process actually work? Because it can be pretty confusing. So we, just on the side here, we've got identify, gather professionals, get an attorney, and go to court. So that's just a simple way to remember what you've got to do here in Wyoming to get this guardianship process figured out. So you may notice that somebody you work with or know from your personal life, your neighbor, somebody at the senior center, lots of different ways you could run into somebody who may have trouble making safe decisions because of a disability. So once you have identified that, professionals will be required to give evidence that the person actually needs a guardian. So the court's going to rely on professional assessments and opinions from doctors, therapists, caregivers, or other people to make a decision about whether that person needs a guardian or a conservator. And then you'll have to get an attorney, which may surprise people from other states. I don't know. There's different processes everywhere, but in Wyoming, the best way to do it is to get an attorney to present a petition to the court requesting that the person get a guardian or a conservator. The court may appoint a GAL, which is short for guardian ad litem. And a GAL is a person, in this case, a person who is an advocate and an investigator. So the court relies on GALs to provide them with an investigation about what's going on in the situation. Does the person really need a guardian? Does the person make safe decisions for themselves? Who should be the guardian of this person? And, are there people available to do that? And who are they? So those are some questions that the guardian ad litem would be answering and providing to the court so that the court can make an informed, good choice. The court will have a hearing so that all that information can be presented to them. After the hearing, the court will make a decision. Sometimes you'll know what their decision is going to be when you're in the hearing. Sometimes you won't. And they'll issue a court order. And we keep harping on court orders. We like those a lot here. They give you some direction in life, which I think is important. So the court order is a super important document that the guardian should keep in their files and read. So we like to stress that. Read that court order. Okay. So who should be the guardian of someone? And in Wyoming, our law gives us some guidance, and my understanding of the Uniform Act is that they give you some guidance too, and NGA, I believe, gives you guidance. So we have lots of guidance about who should be the guardian, but in order in Wyoming is a person nominated by the person who needs the guardian, the spouse of the person who needs the guardian, a person nominated in the will, the parent of the person who needs a guardian or the adult child of the person who needs a guardian, a relative who the person who needs a guardian has resided with for 6 months or more, a relative or a friend who demonstrates a sincere, long-standing interest in the welfare of the person who needs a guardian, any other person, anyone. Any other person whose appointment would be in the best interest of the person who needs a guardian. And finally, last but not least, a person with a professional guardianship program or entity, so Wyoming Guardianship. So, clearly there are way more people ahead of us in line. We like to say that we are the last resort. And so that's one of the reasons why we're talking to all these other people who are in line there on that list, because it's more appropriate to pick one of those people, and a professional guardian should be your last choice. So that brings us to the most important piece. What do good guardians do? There's a lot of different facets to being a good guardian, and we are thankful that NGA, the National Guardianship Association, provides free access to standards of practice and ethical guidelines on their website, and they even have a conference every year that guardians can attend.
That's fantastic. I recommend it.
Absolutely. I believe they even maybe have a scholarship that they give to family and friend guardians, but we've provided their website here, and I think maybe again at the end of the presentation, but we think their guidelines are pretty important and also very helpful. So
yes, we actually adhere to their guidelines as a business.
Absolutely. So what kind of relationships should good guardians build? We'll start out with that. Some of these you may think it goes without saying, but nothing ever goes without saying, so we're going to say all of it.
Don't make any assumptions.
Right? And I always say, my background is as a social worker, and if there's a rule, you can guarantee it's because someone did it before, and everybody was like, whoa, we better write that down. Don't do that. So keep a good relationship with the court. That's pretty important. Know what your state statute is, and I always tell a story where I was at a professional meeting, and there were some questions about guardianship that folks at the meeting were from different states, and somebody was asking for some advice. And my first answer was, what does your statute say? And the person said, well, I don't know. And I said, oh my gosh, well, you should go read that, because no one can answer your question until you have done that. So, it's a little light reading. It's pretty technical. And so I apologize in advance, but it will benefit you to try to read it. File accounting reports and inventories on time and based on what your statute says. Here in Wyoming, guardians file reports with the court every 6 months. Conservators file an inventory of assets within the first 90 days, and then they file a yearly accounting. So, pretty important. Next, we think you should maintain a healthy professional relationship with the person that you are guardian for. So, you should treat that person with dignity and respect, and avoid dating or having a sexual relationship with that person unless you were already in that type of a relationship before you became the guardian. For instance, if my husband needed a guardian and I was his guardian, obviously we previously had that type of a relationship and that would continue. Next, we think you should develop a good relationship with other professional people who provide services to the person under guardianship. Know what your community resources are. Treat other professionals and service providers with courtesy to enhance their cooperation. And actively engage the services of other professionals so that you can meet the goals, needs, and preferences of the person that you are being the guardian for.
I think we go a little bit more into that, engaging other professionals. But it is, and this is not just for only, entities like ourselves as businesses, being guardians for individuals, but you would want, as a family or friend guardian, you would employ a doctor or a dentist if, you needed assistance that way, as you would employ a financial representative to help you, a financial advisor, that sort of thing. And I think that the great thing about community resources too, we've recommended going to, you have local ombudsman, there's long-term care ombudsman that can be of assistance. Our state has a substance abuse and mental health ombudsman program that offers people resources. Your senior centers, community rec centers, all of those places are great places to go and learn about what other resources are out there for yourself and the support of the individual who you're guardian for.
Absolutely, and we may talk about this a little bit more later. I can't quite remember, but one of the things that people express is that it seems awfully overwhelming to be a guardian of someone. This is a big job, it's a lot of responsibility, and what we always say is, if you find community resources to help you, this will not be that overwhelming, because as a guardian, you're not required to provide literal services for the person. You don't have to be the care provider. Some people are. You shouldn't be the financial advisor unless you are already a certified financial advisor. But you can employ those people in a relationship to provide those services, and then you don't have to take that on you're still responsible to make sure that they're doing a good job and that they're doing what you want them to do, but you don't have to have the burden of actually doing that yourself, which I think sometimes makes people feel very nervous about being a guardian.
Right, yeah. Like home health agencies,
personal care agencies.
Yes, all that.
Absolutely.
Just because you become guardian doesn't mean you're having to transport the person all saw their
Or have them
appointments,
come
or
live
go
in your house.
grocery shop.
We get
Yes.
that question all the time. If I become guardian of this person, they'll have to come live at my house. And I always say, oh, no. Oh my gosh, if that was true, we'd be in real trouble, Jesse.
We'd have to open a hotel.
We'd have a lot of people living in our house, in my basement. Okay. All right. So what do good guardians do? Well, they maximize the self-determination of the person under the guardianship. So they provide that person with every opportunity to make decisions that they are capable of to maximize their independence. And if the person wishes, you would try to ensure that they are able to participate in the process to maximize their independence and self-reliance. Sometimes people don't want to be involved, and that's okay, but we always want to make sure that they are invited to the table and that they get to participate if that's what they want. To make decisions that they are capable of. Everybody has decisions that they're capable of. I think we serve as guardian in 180 cases.
No, 180.
180 of those cases, people can choose. Everybody can choose at least one thing that they are making a choice about, whether that's from what they want to eat to what they want to wear, up to bigger decisions
during the day,
who they want to socialize with. But sometimes they might not be able to do that in a way that you think, because they might not be like, I do not like Melba, and I do not want to sit by her. They may tell you in other ways, but they are choosing, and you need to listen to what their choices are. Yeah.
The caveat though, as long as they're healthy and safe.
Safe. As long as it's safe. We do get that one a lot. You just let people do whatever they want. Well, no, that's not true. We take that pretty seriously as the guardian. It's our court-appointed responsibility, but we want to make sure that whatever the people are choosing, if you're letting them choose, which you should be, that it is safe and it's not going to harm them in some way. So you should also understand and account for the person's diversity, including their ethnic, religious, and cultural views. It is the guardian's duty to find out what the person believed about death and dying, about quality of life, about funeral and burial customs, about illness and relationships. It's your duty to find that out, what they believed about that. And sometimes when people have been disabled since birth, what their family believed about that, because, sometimes you're born into a family that has specific ideas and thoughts about that. And just because you have been disabled since you were born does not mean that you don't, have a milieu in that relationship. So.
Yes, I think that kind of goes back to shaping with letting them be part of the process and making decisions. Because if you do have to make a decision for them, you should be doing that based upon what that person
would have done if they had competency, or what their family cultural values and religious values are. And then lastly, understand that the person has a right to interpersonal relationships and sexual expression. And, we have a lot of questions about this and concerns about it, frankly, too, especially from family guardians, where perhaps you have someone who has been the guardian of their child, for a long time, and now the child is an adult. The child wants to, date or have a relationship. Maybe the child is gay. We have a lot of LGBTQ questions. People with disabilities want all of the same things that we want. They want to have a relationship. They want to date. They want to get married. People with disabilities are LGBTQ. So you want to make sure that you take into consideration consent and possible victimization and privacy, but this is not something that we should shy away from as a topic.
Definitely.
Yeah. Next. Okay. Responsibilities. You're doing great. So keep the affairs of the person under guardianship confidential. People still have a right to privacy. Respect the person's privacy and dignity when it comes to the disclosure of information. So just because you're the guardian doesn't mean you go around willy-nilly saying all kinds of personal, private stuff that would be embarrassing. Right. Visiting the person at least monthly to assess their condition and what their living situation is like, making sure it's safe and appropriate.
Yeah, safe and appropriate.
Safe and appropriate. Remain in substantive communication with the person's caregivers and service providers. So It's very hard to ensure if the person's living situation is appropriate if you're not in communication with their caregivers and service providers, don't you think?
Yes. We always say the issues come when there's not enough communication. I think that's one of the biggest things about being a guardian and working with other professionals in that person's life and the person themselves. We want to always make sure that everyone's on the same page and communicating.
Absolutely. And please, please participate in planning and care conferences for the person. We sometimes run into folks who think the world of the provider, and that's awesome. We have some great providers in Wyoming. And perhaps the person they're guardian for has resided with a specific provider for many years. And we have run into situations where people were like, oh no, they just do all that. They just do such a good job. We just let them do all that. And we're here to say, please don't do that. Please don't do that. People's employees change, people's ownership changes, people's missions and values changes, and you should always be involved in the planning and the conferences for the person that you are the guardian for, and do not just let their provider do whatever because they're good. Providers may be really good, but it's your job to be involved in that relationship. Okay, so this one's kind of a tough concept for lay people, I think. Good guardians make good decisions. So how do you do that? Well, we've got two ways to do it here on this slide. We've got the winner, winner, chicken dinner section, which is substituted judgment. And then we've got best interest, which will work when substituted judgment doesn't. And I think part of the reason for the confusion is everybody says best interest like it's a thing, right? Like, well, we'll just do what's in her best interest. Well, if you would just do what's in their best interest. Well, when we're talking about guardianship, we mean something a little bit different by that. So substituted judgment substitutes the decision the person would have made when they had capacity. It promotes self-determination and well-being, which we really, really want. And it's not used when the person's wishes could cause harm to them or when the guardian can't figure out what the person's goals and preferences were. So again, substituted judgment. You have Jessie. She's been in a car accident. She has a substantial brain injury. She's now has a guardian. And in substituted judgment, the way that I would be making decisions is to find out what Jessie would have done before she had the accident, before she became a person with a guardian. What choices would she have made? And then I would do that. Even if it's not the choice that I would have made, I would do what Jessie would have done, as long as it does not cause harm to her. So that's substituted judgment. In best interest should be used when a person has never had the capacity to make decisions, or when the guardian cannot figure out the goals and preferences of the person, or when what that person would have done would cause them harm. Best interest is considered the least intrusive, most normalizing, and least restrictive choices possible. That's what you should be considering when you're using best interest as an option. And you know, there are a lot of times when you do have to use best interest. Sometimes, you know, we've gotten folks here at Wyoming Guardianship where when we came to them as a guardian, they couldn't tell us anything about their life before. Sometimes we didn't even know we've got people where we didn't even know their names. So, you know, we really could not ascertain what they would have done. And then you're just doing what is you think in the best interest and using your own, you know, moral compass to figure that out.
And we would try, you know, if that person couldn't communicate that, you know, to locate family or friends, religious, you know, like maybe a pastor who would
religious community members.
Yes, exactly. To try to get to know that person to be able to use either substituted judgment or truly, you know, the best interest of the person.
It'll give us some guidance about what they would do based on the information from those other people. So, all right.
I'm struggling here with this mouse. There we go.
Okay, gives me a chance to not talk. So, what about a conservator? Does the conservator do the same things as a guardian does? Well, in Wyoming, the conservator is the guardian of an estate. Just like the guardian of the person, the conservator gives priority to the goals, needs, and preferences of the person under guardianship. The conservator is going to weigh the costs and benefits to the estate of the person. And the conservator should follow the general guidelines about guardian of the person that we already talked about. But because they're managing an estate, they have some very specific duties. So, what are those? They are providing oversight for the income and assets of the person. They are providing competent management of the person's property. Caveat, we do not manage property here at Wyoming Guardianship. We hire people who do that for a living to manage property. And my suggestion to you people out there in internet land is that unless you spent your whole life as a property manager and you feel super comfortable doing that, hire a property manager if you have someone that you're the conservator for that needs property managed. The conservator is going to supervise and document all income and disbursements of the person's estate. They're going to keep the person under guardianship's money separate from their personal money, which I think is very important for lay people, family, friends, volunteers. You definitely do not want any of your money commingled. You're going to apply the law regarding prudent investment practices, including seeking consultation to people who have expertise, or delegating this to people with expertise. Ask the advice of an attorney, get a financial planner on board, hire a real estate agent. You know, all those people are experts in their field, and you should hire them to get advice and get help for how to do this.
So it'll be a relief for you too, to know that you don't have to make all those decisions, and that you can have that guidance based on these professionals' opinions.
And we frequently remind our staff of this too, right? I mean, I think it can get a little overwhelming for everybody. You think, oh my gosh, there's so much to do. How will I know how to do all of this? And we frequently say, okay, take a deep breath and know that you're going to hire somebody to do this. You're going to hire somebody to do that. You're the, is this the part where we talk about our puzzle pieces?
Program management.
Yeah, what we usually compare, we usually use a metaphor. And we think that guardianship and conservatorship is like project management. And so as the project manager, your job is to make sure, if you use a construction analogy, you know, if you're, managing a project as a contractor, you want to make sure that the people doing the floor come in before the people who are putting in the cabinetry, right? And so as the guardian and conservator, you're sort of doing the same thing. You're watching all of these people that are coming in. You're making sure that they're coming in at the right time, that they're doing the right things. You're not doing all those things. You're not laying the floor yourself. You're not putting in the cabinets yourself. You're making sure that the people that you've hired to do those are competent at it, that they're coming in at the times you want them, that they're on the trajectory that you've set. So we really feel like guardianship and conservatorship is a lot like project management, and you're overseeing all of these pieces that are going together in a big puzzle.
Right. You're building the house.
You're building the house, or putting the puzzle together and making sure all the pieces are going where they need to go. So, we have, we think you should employ a prudent accounting procedures while you're managing the estate. You can also ask for help with that. And again, property management doesn't mean actually managing the property. You do want to make sure that any property that you're managing is insured, and that if you're going to dispose of it, which we really mean liquidate it, just in case you think, dispose, or you're trying to liquidate it for money for something else, you have to get court approval for that. And then obviously you want to provide an inventory to the court within the first 90 days of your appointment, and a yearly accounting. And so the yearly accounting should check back to that inventory. So if you've disposed of things, it should match. You should be able to tell in the accounting where all of that went. Just takes twice.
Double click it.
All right, so ethics. Conservator specific ethics. Value the well-being of the person over the preservation of the estate, which I think is a great piece of advice for family conservators. So rather than your intention being to preserve the estate, your intention is the well-being of the person that you're the conservator for. Manage the estate only for the benefit of the person that's under conservatorship or guardianship. Not for the benefit of anybody else, not for the benefit of your contractor friend or your realtor friend or whatever, the benefit of the person. And don't have a conflict of interest. So you should not personally be benefiting from the management of the estate. So, if you're considering quitclaim deeding property to yourself, please reconsider that. This is the kind of stuff that, it should not benefit you personally to manage the estate of this person, whether it's your mom or your neighbor, or somebody you've never met and you just volunteered to do some pro bono work. It shouldn't benefit.
And I think that kind of goes back up to the value, valuing the well-being of the person.
Yes.
So, sometimes we've seen with family guardians that they know that they are going to be inheriting, property or money. And so instead of, saying, putting home health agencies to come in and help your mother be, having the best, should we say, quality of life.
Sure.
They're saying, oh, no, we don't want to spend that money because I'm going to inherit that money. That is not ethical.
Yes.
You wouldn't want to do that.
And again, this goes back to some of you out there in internet land may be thinking, who would say that? Well, lots of people, actually. So, we're not value judging that thought process. We have parents, we have grandparents, but yes, your interest in how much is in that estate is not, necessarily should not go into your decision-making process if you are the conservator or the guardian. All right, so we get tons of questions about this, and I'll tell you specifically what ones here in a second, but when is a guardianship over in Wyoming? When the guardian dies, when the person under the guardianship dies, if the person under the guardianship becomes competent again, or if the guardianship or conservatorship is transferred to another individual or an entity. So most of the time we get questions about this when you have somebody who is very tired and stressed out, a guardian or a conservator, and maybe they're getting up there in age, maybe they have a health issue, maybe the person they're guardian or conservator for is just a real pill and it's taken a lot of time and energy, and they'll call here and say, I'm not doing this anymore, I'm not the guardian anymore. And so what we usually say in varying degrees is, oh yes, actually you are, until the court says you're not. So let us help you figure out how to get the court to say you're not. If the guardian dies, obviously that's going to end it, but we would hope that the court would appoint someone else if the person still needs a guardian. If the person under guardianship passes away, then obviously guardianship is over. If the person under guardianship or conservatorship becomes competent, which does happen, especially with mental health illness, maybe even a brain injury, different types of disabilities, people regain competency all the time. It is the guardian's responsibility to tell the court that you think that the person you're serving has become competent again, so that the court can evaluate that and so that they cannot have a guardian if they don't need one. And then also guardianship or conservatorship can be transferred to another individual or an entity. Wyoming Guardianship takes these all the time. Again, you have the people who maybe have a health condition, they're getting older, they're just tired. Maybe the relationship is such a struggle that they can't do it anymore. Then the court can substitute. They can remove that person and put someone else in. In our case, we usually do that with Wyoming Guardianship.
Well, and so that kind of leads into a little like we have been or are standby guardians. So say if there's a guardian and a mother and she's getting elderly, and she knows, she wants to have that peace of mind that someone else will become guardian if she dies. Mm-hmm. And so, you can get a court order that's in place that says, when that guardian passes away, that then the next entity is already named in that case to then step in and take over guardianship at that time, which is a nice precautionary measure.
Yes. It really helps family and friend guardians and even volunteer guardians feel a little bit more comfortable with, what will happen, if something happens to me. And it does ensure that there's not this space where the person isn't being served and has nobody making decisions for them if they need that. So it's helpful. Okay, does everyone with a disability need a guardian? Oh my God, no. Guardianship is the most restrictive level of care available. It should only be used when there is no other safe alternative, and definitely tons of people with disabilities out there who absolutely do not need a guardian or a conservator. So,
well, I think we've talked about there's a new model of shared decision-making that is becoming a lot more popular throughout the country, and that is one kind of what we say like a stopgap measure to help people, from being exploited or,
help make good decisions, but not necessarily if they need it to the level of a guardian. And I think we have a list of that, actually. What's next? Oh, it's too fast.
Double.
Okay. So speaking of that, there are alternatives to guardianship.
Supported decision making.
There are alternatives. So some of the big ones, there's probably other alternatives to this too, but these are our big ones. Supported decision making, which Jesse just talked about. There are, supported decision making. You could give a whole presentation on this, but in general, surrounding the person with professionals and other people in their life who they trust, who have their best interest in mind, who can help them make a decision. They cannot legally make the decision, but they can help the person, through that process and coming to a conclusion. And there are some forms that are helpful for this. And I think we've provided in the next slide a website for supported decision making where they do have some of those forms available, but we think it's a great alternative. Representative payee, I always say, boy, money is the bane of all existence, is it not? Like a lot of times when people think that a person needs a guardian, it's really because they're having problems managing their finances, and a lot of those folks really only receive Social Security as income. And so in that case, if you can have a representative payee appointed, the person may not actually need a guardian at all. Same thing with special needs trusts. A person gets a windfall. A person with a disability gets a windfall of money. People are super worried about, them being taken advantage of, them spending it, all at once, or whatever it is that all of us would do if you all of a sudden got $500,000 or whatever. And so how can you manage that? Special needs trust or ABLE accounts, you now have those, then it puts somebody else as a stopgap in there who's going to be making sure that that is protected. And then finally, advanced medical directives and living wills, where as a competent person, you spell out with your attorney very clearly what you want to have done. And so when you become incompetent, it's very clear, or when you become disabled or whatever's happening, it's very clear what you want to have done, and you don't need something extra because you very clearly spelled that out, and it's easy for everyone to follow. So.
Yeah. That's kind of like with DNR. You can put you don't want to be resuscitated in your advanced medical
or HOLST or MOLST or whatever your state's using. Of course, we would recommend to all competent people of all ages to do all of those things ASAP, because you never know what might happen. And boy, we are sad when we get cases where we don't have any of this stuff. Just really tough. So
very helpful.
All right, so here's some of the resources we have for guardians and conservators. Of course, NGA's National Guardianship Association's website, specifically for their standards. They also have some ethical guidelines that are super helpful, I think. The National Resource Center for Supported Decision Making, which explains that in greater detail and provides some forms that I think are super helpful. Social Security Administration's Rep Payee program. Give some great information on that. And then finally, our website, hopefully, we can provide you with some other information as well, or our contact information, because we would welcome emails from you. Right down here on the bottom is Jesse's email and my email, and of course our phone number. It is easiest to reach us by email, but we would welcome your questions. We'd love to help you. So shoot us an email if there's anything that you think we can help you out with. And I think that's our presentation for today, and we hope it's helped you learn how to be a good guardian or conservator. And thanks for tuning in.
Thank you, everyone.